So how will you get paid? Good afternoon, and to some of you, good morning. I'm Anthony Kapkin, editor of Electrical Business Magazine, and welcome to our summary of the expert review and report of Ontario's Construction Lien Act. And while this webinar focuses on the scene in Ontario, review leaders Bruce Reynolds and Sharon Vogel assure me the rest of Canada is watching closely. Speaking of which, it's nice to see we have some registrations outside of Ontario, including Quebec, British Columbia, Newfoundland and Labrador, and Saskatchewan, with a great mix of contractors, distributors, and manufacturers. Welcome to you all. Today's speaker grew up among electricians. Dan Leduc is a partner in the law firm Norton Rose Fulbright Canada LLP and practices almost exclusively in construction law, advising and representing owners, engineers, subs, suppliers, and builders. He regularly speaks at construction industry conferences, and he helped industry groups prepare submissions to the Lien review team. Now, there will be time after Dan's presentation for Q&A. Just type your questions into the questions window, not chat, but the questions window, in your webinar control panel, and you can do that at any time. Now, please welcome Dan Leduc.
Thank you, Anthony, and welcome everyone. This seminar presentation is, as Anthony identified, a summary of the report, the expert review of the Construction Lien Act, which was released in September of this year. So let's get started. So who am I? As Anthony identified, I'm a partner in a law firm called Norton Rose Fulbright. My practice is exclusively in construction law, and my involvement actually with the review process was being engaged by a group called Prompt Payment Ontario, which was essentially the Ontario caucus of the National Trade Contractors Coalition of Canada, to make submissions on behalf of subtrades in Ontario in respect of amendments that were coming to the Construction Lien Act. So I was part of the process, a small part, but still put together, part of a group that put together a submission that went to Mr. Reynolds and Ms. Vogel as part of PPO submission. Ultimately, you want to be asking yourself, what do I want to get from this seminar? What do we want to get through in this seminar, in this webinar? Ultimately, the report that came out, which was released in September, is 435 pages long. I have an hour window here to get you through what I think are the more significant portions of it. So again, as Anthony identified, if you have questions at the end, certainly feel free to ask them. If we run out of time for whatever reason, my email address will be at the end. I'm happy to answer any questions you may have afterwards if that works for you as well. You may ask, why is there an IKEA man up in the top right-hand corner? Why are you using the IKEA theme? Well, if you've ever thought about the instructions and putting together IKEA furniture, you'll realize that it looks a lot easier than it is. For the Construction Lien Act application in Ontario, try to imagine writing one set of rules that would apply to every construction project, whether it's a residential renovation of a kitchen right through to a heavy-duty cogen plant. One set of rules that would apply to every construction contract. It sounds a lot easier than it actually is. The Construction Lien Act is a lot easier when you read it than it is in application, and that's why I've used the IKEA theme, and that's why I say welcome to the Lien Act. So before we get into the particulars of the actual Reynolds report, how did we get here? How did we get to a situation where the government of Ontario had to engage lawyers to go out and make a recommendation on changes to the Construction Lien Act? Well, the Ontario Construction Lien Act last had a major overhaul in 1983. So you have to think back, 1983. Well, yes, the last time the New York Islanders won the Stanley Cup was in 1983. It's that long ago. Okay, so it was certainly overdue that there would be a review of the Lien Act in full. Again, how did we get here? Well, you have to think of the context of how this report would evolve and how it can be applied. The industry itself has its own inherent risks, and I'll take you through an example here. If you think of your typical risks in terms of payment in the construction industry, you have to think of it in two different platforms. The first platform would be prompt payment. So that is getting you timely payment so that you become and remain as cash neutral as possible. So the whole idea is that every dollar that goes out, I've got to retrieve that dollar back into my coffers. Otherwise, I'm going to be extending financing to the project. So again, being cash neutral is the goal, and that is the prompt payment platform. The second platform is called payment security. And payment security is if you're not paid properly, how can I go about ensuring that I'm going to get paid? And that is taking security, and that is typically lien security, whether it's a claim on the bond, other forms of claims that you might have. But ultimately, the goal under the Construction Lien Act is to take lien security, okay? So if you're a contractor in payment, obviously you don't want to be in the situation identified at the bottom of the screen, but do think of it in terms of those two platforms, prompt payment and then payment security. Again, it is a risky business. If you think of other industries outside of construction, most of them operate on the following very general parameters. If you are, for example, a manufacturer, you determine the market need for a product. So if it is shoes, okay, ultimately you will determine if there's a market need, if there's some penetration in the market for a new type of shoe, a new design of shoe. If you determine that there is, then you design that shoe, that product. Ultimately, you determine the product's price in advance of manufacturing the product. You get to see your competitors' prices for similar or same products. You control the schedule for the manufacturing of your product. Then you manufacture the product. You mark it up for overhead and profit. You dictate the terms of sale, whether it's on consignment, whether it's by lot, however you want to sell, whether it's online, direct from the manufacturer. You determine the terms of sale, and it is typically your contract for that purpose, and then you sell your product. And you get paid typically 100% for the product upon sale. You people, however, are in the construction industry, and that's something completely different. Ultimately, in the construction industry, someone else determines the market need for the product, whether it's a building, a road, a solar plant, whatever it is, someone else will be telling you whether or not that product is actually needed. Someone else designs your product. You have little control as a contractor and no first-hand information about design, unless it's design build, and even there as a contractor, you will go out and engage the services of a third party. You guess. You people call it estimating. You guess your product's price in advance of manufacturing the product based on someone else's design, someone else's schedule, someone else's specifications and drawings. You never get to see your competitors' prices for similar or same products. You should all be nodding your head up and down, otherwise we'll have to do another webinar on the Competition Act. Your contract terms are largely dictated by an owner, its consultants, and if you're a subcontractor, the general contractor. Then what you people do is you sell your product. You lock yourself into typically a fixed price contract even before you mobilize the site. Then you manufacture your product pursuant to someone else's schedule. And then you get overhead and profit if your guess, what you call estimating, was correct. Therefore, it's almost the reverse. In fact, it is the reverse of the manufacturing industry. You actually sell your product, then you manufacture it, then you only get overhead and profit after the process, after you determine if your estimate, your guess was correct. All that to say that you are in a much riskier venture than normal industry. The key becomes managing risk and protecting your interests and getting paid promptly as part of that process. How else did we get here? Well, add this to the following, the risks that we've looked at so far. Okay, so if you think about judges, courts, and construction law in Canada, and I have ultimate respect for our judges. They do work hard. They do not work bankers' hours, I can assure you of that. But what you have to remember is that judges in this province and in this country, and I've appeared across the country in a number of judges, anything that goes on in society can end up in front of them in a courtroom. So whether it is, you know, a fence dispute between two cottages, a shareholder's dispute, a trademark dispute, all of those things, whether you're passing off on intellectual property, any of those things, divorce, criminal matters, sentencing, all of that, everything that goes on in society can end up in front of a judge. And what does that mean to you as a contractor or in the construction industry? That means that because construction occupies a small portion of what goes on in society, our judges know very little about what goes on in the industry itself, and that raises the risk of having a judge make a determination in your dispute. You're essentially handing over a dispute that you have to someone who knows very little about the context of the dispute, needs to be educated on what goes on in your industry, and so on. Okay. Plus, on top of it, the priority is given to criminal and family law matters, especially in this province. So they always get a priority, and therefore there's automatically going to be delays in getting your matter to trial because those matters are given priority, okay? Going to court is ultimately the worst way you can manage risk, and if you have to litigate, it is often too late in terms of managing risk for payment and securing payment. Bottom line, you want to avoid courts and judges, but ultimately you may need someone, a third party, to make decisions and get you a quick resolution, okay? But your main goal should be to avoid having to go to court. How else did we get here? Reason number 3, your margins. And obviously I don't need to know or see your profit margins, but let's take a look at the industry as a whole. And what we have, and albeit it's discontinued now, are from StatsCan, what are called quarterly financial statistics for enterprises. And you can find these documents on the internet. And again, unfortunately, they are discontinued. They used to be coming out quarterly, obviously, but for some reason, the Government of Canada has decided to discontinue these. But let's take a look at the last available one, which gets us up to the fourth quarter of 2015. And, it's a 118-page document, but I've carved out here the portion that deals with profit margin. If you look at construction, I've highlighted it there, 7.6%. And you're asking yourself, well, how would StatsCan know that? Well, we do have some construction companies that trade publicly, and they do anonymous polling. They do phone calls and so on, and that's how they determine the industry's return on profit. So 7.6%. Okay, well, what should that tell us? Well, it tells us that you're mid-range compared to other industries, and I haven't included financial industries. This is non-financial industries. I don't want to make you more depressed by seeing what profits the banks seem to take. It's all, don't worry, it's all above 20%, but you're in the middle of the range. Okay, so there's some industries here that are much higher than yours, and a few in retail and so on that are much, well, not much lower, but lower. Okay, but what the 7.6 should tell you is in Ontario, the holdback's 10%, and even in Manitoba, it's 7.5%, but ultimately, most common law jurisdictions, the holdback is 10%. Well, if your profit is typically 7 points on a project, that means that you're only getting your profit when you get paid your holdback. And when are you getting paid your holdback? Certainly well after the project's been completed. And ultimately, if that's where your profit's going to be, okay, then you can start thinking in terms of being in a negative cash flow for the duration of the project. So again, your margins help dictate some of the risk and some of the reasons why there was a review of the Construction Lien Act. Reason number 4, how did we get here? Cash flow. Okay, so you have handicapped odds against you. You're being paid on 60-day terms, and if you're lucky, it's 71 days, because that is becoming the apparent norm. And I have this sketch here from another Statistics Canada diagram, but if you look at it, you'll see a comparison going back from 1999 through to 2013 on average collection period in number of days based on your invoicing. And you'll see here that all non-financial businesses are running as of 2013, 2014 at around 46, 47 days. Yet construction, for some reason, is up at 71 days. And you'll see the hiccup there in 2008, and I can't explain what happened midway through 2008 other than we went through a recession. And I guess the construction industry was simply happy enough to have work that it wasn't worried about how timely it was getting paid. That's the only explanation I can find. But really, when you look at this, it's quite telling. It shows you that there was a real problem in the industry in terms of cash neutrality and getting paid promptly. And again, dealing with cash flow, as part of the Prompt Payment Ontario group in our submission, we actually engaged Ipsos Reid, who did a survey in terms of how late payment was impacting their business. And I'll just leave this on the screen for a few seconds. You can read it as well as I can read it to you, but you certainly see the impact that late payment has on, reduced employment, smaller competition pool, diminished productivity, and increased costs. Those are all negative impacts on your ability to make a profit and operate efficiently. I'll just leave that up there for another 10 or 20 seconds. So again, add everything that we've looked at so far, add to that the following. Okay, so we know that you're getting paid on 45+ day terms, and if you're lucky. 70 days is becoming the norm in Ontario in terms of getting paid in the construction industry, you only get paid 90% of your invoices, right? Because of that 10% holdback notion, and you only get that paid after you've completed your work. So you're already going to be at a negative cash flow at 90% of your invoicing. You have to pay for your labor weekly or bi-weekly. You're required to pay your suppliers net 30 days, and typically suppliers will induce you with 2% discounts if you pay sooner, or some kind of discount if you pay sooner than 30 days. Owners and consultants are becoming more aggressive on draws and are in tune to front-end billing and overbilling. You have to remit HST in Ontario on invoice values despite the fact that you may not have yet received payment on those invoices. And for most of you, that's a monthly undertaking. So you've got that commitment. So you're going to pay tax on invoices that you've sent out but haven't received the money yet. Ultimately, all that being said, you're effectively financing your own work and operating on negative cash flow in an industry that's totally premised on cash flow. And you start thinking, at what cost? Why? Why do I have to go through this? So the Reynolds report, as I said, came out in September of this year, although it's dated April of 2016. The Ontario government had it. It had to do a translation. That took a long time. They had to have everybody back from summer holidays before it was released. It was a cabinet shuffle that took place earlier in the summer as well. But ultimately, it came as a result of the fact that timely payment in construction is an issue and remains an issue. Some of you may be familiar with something that was called Bill 69, the Prompt Payment Act of 2014, which was a move afoot by a variety of groups strictly dealing with the sole issue of prompt payment. It preceded by a private member's bill, which was ultimately shot down in early 2014. And then what we had was the Government of Ontario retained the services of Bruce Reynolds and Sharon Vogel to do a review of not just prompt payment. Certainly that was only one of the issues that they wanted to look at, but a complete rehaul of the Construction Lien Act. And this site here will give you a copy of that act. If you want a shorter site, I've used a URL shortener to give you an easier way to access the document at that site there. I'll leave that up for another 10 seconds or so people can write that down. And the report itself, there's the copy of the first page. You can see the authors' names at the bottom, Bruce Reynolds, Sharon Vogel. I mentioned earlier it's quite lengthy. The chapters are split up into 14 parts. So those were the issues that they were looking at. The issues, lienability is the ability to register a lien for the work performed. So as an example, you get into issues if I'm supplying a generator to a project and it's on a pad and it's bolted down on a pad, that's the type of equipment that can be easily taken from one building and applied to another. Is that something that would qualify for the Lien Act, or is that something that is a movable, that's not part of the improvement as defined under the Act? So they looked at lienability, they looked at preservation, perfection, and expiry liens. Those are the fancy words for registration and starting the lawsuit associated with liens. Holdback in Chapter 5. And you can read the rest of the chapters there as they went through. So it wasn't just prompt payment. You'll see Chapter 8 deals with promptness of payment, but they certainly looked at a wide range of issues covering off most of the topics required for addressing changes under the Construction Lien Act. When you get through the document, if you get to it, you'll notice that there's 1,957 footnotes, so it's quite a thorough document. It's not a light reading. There's 130 or 435 pages, as I mentioned earlier, in the document when you download it from that web page. Okay, so it's an extensive document, 2 years to put together. Received a number of submissions, interviewed a number of people. It's quite wide-ranging. So I want to take you through not certainly all the recommendations because there's over 100, but the ones that I think are going to be key going forward. And again, these are just recommendations made to the Government of Ontario. We have the Attorney General, Mr. Nakvi, telling us that he said that he's going to push this forward in early 2017. But again, these are just recommendations. So this is not what the law is currently. It's what the law is recommended to be. And then obviously there'll be a process, the legislative process in the province to bring forth the changes that were recommended. But recommendation number 47 deals with prompt payment. And it says that we recommend that a prompt payment regime be legislated in Ontario and that it be applied to both the public and private sectors. Prompt payment should be implemented by creating a statutory scheme to be applied into all construction contracts that do not contain equivalent terms. So that's, to me, the first real dramatic change to all of this is that they are advocating a prompt payment type of arrangement. Now, almost all 50 states have some form of prompt payment legislation. Some of it only applies to public projects, others applies to both public and private. There are other countries that have prompt payment regimes, and again, the document that you can upload from that webpage that we looked at earlier will take you through the whole history and other legislation around the world that deals with prompt payment. But again, this to me is one of the key provisions dealing with prompt payment, okay? Some of the highlights within that prompt payment chapter include that you're going to have a monthly invoice schedule unless it's otherwise negotiated. The schedule for payment will be from the owner to the general contractor, 28 days, the general to the sub, an additional 7 days. They're recommending extending the time to register a lien to 60 days. And they'll explain why in the document. I can't take you through all the reasons why here. We only have an hour. But ultimately, those are pretty dramatic changes. Now your cash flow, if you're a subcontractor, you're looking at 35 days in terms of payment, rather than likely the 71 plus that you're looking at now, so a cut in half. If payment is going to be withheld from you, they are recommending that you, as the receiver of the payment, the debtor, receive notice within 7 days of the date of your invoice, setting out the quantum to be withheld and the particulars of why it is being withheld. So at least you'll know, at least you can plan now very early on after your invoice, knowing that whether or not you have an issue, whether I have to engage a lawyer, at least you can prepare yourself for something that is coming. And the set-offs will be limited to the work that is subject to the contract. At times we have certain contractors setting off damages or deficiencies relating to another project on a payment. That will not be permitted based on their recommendations. Still keeping with the recommendation number 47 on prompt payment, they added the following. We recommend that the trigger for payment should be the delivery of a proper invoice, provided that certification for payment, if there is certification, must follow submission. And that ultimately, my first question was, what qualifies as a proper invoice if that's going to be the trigger? The trigger for a proper invoice, and the proper invoice is defined as one that has the following components to it. So the name and address of the contractor. I suspect most of you are doing this already, but they just wanted to define it because it is key as to when prompt payment, the trigger would start. The invoice date, the contract number or other authorization for the property delivered or the services provided, what was performed, okay, the description, quantity, and the price of the property delivered and or the services performed, the shipping and payment terms, if there are any, the name, title, telephone number, and complete mailing address of the responsible official to whom payment is to be sent. So whoever's the debtor is going, or the creditor is going to have to pay you, they have to identify a person of which you would be directing your invoices to, and then the name, title, telephone number, and complete mailing address of the responsible official to be notified in the event that the invoice is, sorry, there's a spelling mistake there, is defective, and any other substantiating documentation or information required by the contract. So I would suspect a number of you are doing this already, but this will be, should this legislation go forward in its current recommendation, what would be required to trigger a proper invoice. Still keeping with prompt payment, you're going to have mandatory non-waivable interest on late payments, okay? In typical Anglo-American business practices, how you deal with a late payment is through the charging of interest. Banks do it, credit cards do it, you know, your cell phone companies do it, everybody does it. It's a normal occurrence, and I suspect many of the contracts that you sign as a contractor have an express provision for payment of interest on a late payment. None of you enforce it, none of you pursue it, typically, very general terms, but this will have mandatory late payment and you will not be able to waive it or contract out of it. So it'd be mandatory interest on late payments. No financial disclosure obligation. There's no need to have the payor identify how it's financing the project, as an example. Pay when paid clauses will be permitted, okay, but subcontractors must be notified of the owner's default, and general contractors must undertake or commence collection proceedings. So they're still going to allow pay when paid clauses, and if you think back, if you knew what was going on with Bill 69 in 2014, those were in that draft legislation, which was never approved. They were trying to strike out pay when paid, but ultimately they will be permitted, but there will certainly be obligations on the general to pursue the money immediately on your behalf. As an aside, Ontario is one of the few jurisdictions that still fully enforces pay when paid clauses. Other jurisdictions have said, yeah, it's simply a timing mechanism that allows the general contractor an opportunity to go and pursue the money from the owner. It's certainly not an absolute defense that there would be no monies paid after a certain reasonable amount of time, but Ontario still maintains generally that that is an enforceable contractual clause that under the freedom of contract that you're allowed to sign and pursue. As an aside, when I was going through this with Prompt Payment Ontario, one of the things that I'd never thought of was the impact of late payments on benefit plans, and the Reynolds report takes you through some of the impact of that. We made that as part of our submission through PPO, and it was really education for me to understand how these late payments impact the benefit plans that the workers have through unions and otherwise. So you'll see some chapters in there dealing with that specifically. It certainly was an eye-opener for me. Again, keeping with prompt payment, you're going to have mandatory release of basic holdback. What does that mean? Well, currently, if you look at Section 24 of the Construction Lien Act, it says a payer, so somebody who's paying money without jeopardy, can make payments, and it says a payer may, without jeopardy, make payments on a contract up to 90% and so on. And then it says, effectively, uses the word may again for the release of the holdback, okay? Effectively, what they're trying to do here is recommend that the may get changed to shall. So at day, well, it'll be day 60 or day 61, if your lien period is 60 days, there will be a mandatory release of the holdback on that day. So to me, that's critical and key and new, obviously. In terms of deficiency holdback, it's not implied, so there's no automatic right to a deficiency holdback. But if there is going to be a deficiency holdback, it can be something that can be negotiated at the outset of the project, if that's a term in your contract. You're going to have to, or the owner's going to have to, maintain a very detailed set of particulars and details as to what is deficient and the value of it. And it's going to be subject to something called expedited adjudication, which I'm going to get to in some slides going forward, okay? And then there's going to be a tighter definition of substantially performed, which triggers the obligation to publish notice and timing to release the basic holdback. So, for example, and I think this is where they're going, sometimes you can see when you look at on the Daily Commercial News website, you'll see that the Certificate of Substantial Performance is signed on August 2nd, 2016, but it's not published until September 18th, 2016. So there's like a 6-week gap between when substantial performance was actually certified and signed and when it's published. And obviously the release of the holdback gets triggered and the lien rights get triggered by the publication date and not the date of the certificate. I think they want to shorten that so there's no sitting on the Certificate of Substantial Performance that it gets published right away. Otherwise, that lag just gives another 6 weeks as to when holdback would be paid, as an example. Continuing with prompt payment, you're going to have what's going to be characterized as a statutory default if the parties do not negotiate a dispute resolution system consistent with the new act. So we'll get to the slides dealing with adjudication, but if you don't have something that is equivalent to that, you're going to be in default of the statute. I don't know what the penalty will be, ultimately we have to see in the legislation that comes about. Decisions under this adjudication system, and as I said, I'll get to some slides dealing with that shortly, will be binding and must be implemented. They're going to be enforceable through the courts. You will have a right to appeal, and none of this impacts your lien rights. So this adjudication system that they want to advocate will not impact your lien rights. The last thing with prompt payment that you'll want to consider is after an adjudication and after an order is made on that adjudication, and if a payer is still in default, then the contractor or the subcontractor has the right to suspend work, which would allow you the right to demobilize from site without penalty. Okay, and that's something that we were advocating in Bill 69, which comes through here. So you will have a little bit of leverage should an order be made and there not be any curing of the default by reason of that order. Now, I did talk to you a little bit about holdback reform under their recommendations. Let me explain why with PPO we were an advocate of holdback reform. And I mentioned earlier that PPO undertook a survey through Ipsos Reid, and part of the results of the survey are here, figure number 13 from one of our submissions. And what you want to focus on, I'll leave this up here for a minute or so, what you want to look at is that number there. Okay, so your holdback, this is length of time that subcontractors actually waited for holdback monies over the past 3 years. And 82% of those who answered the survey said that they had to wait 46 days or more. Okay. If you start looking at some of the other numbers, you have 25% that are 91 days to 180 days. So that's a quarter of the respondents. And then you have almost 10%, 9.2% of those who were over 180 days, over 6 months to wait for your holdback. That was a large reason for the impetus for us asking that there be a mandatory release of holdback. And again, remember the importance of your holdback, your profit. If your profit's less than 10 points, you're not getting your profit until well after the project's done, after you've expended all the money. And now you're financing, now you're deep into your pockets to keep financing the project without being paid. Okay, so I'll leave that up there for another 10 seconds or so to give you a sense of what's involved, but it's pretty dramatic when you start seeing the effects of having a late paid holdback, just the holdback alone, let alone your progress draws throughout the project. So as I mentioned earlier, there will be a mandatory release of holdback, okay? And as I took you through earlier, and we'll go through this, deficiency holdback is to be addressed, and there'll be a tighter definition of substantial performance. Also, there will be some amendments to facilitate partial and earlier release of holdback. We still have that issue where you have contractors who finish a project early. So if they're doing excavation or steel erection or concrete placement, we have a provision under Section 33 of the current Construction Lien Act that allows those early finishing subtrades not to have to wait till the end of the project to get their holdback release. But the process to do that is kind of difficult because you're trying to convince the consultant to sign a certificate under what is Section 33 to certify that your work is 100% complete, and then you have to leverage that with the owner who's got to now draw down on the financing of pay you out of its holdback fund earlier than it was expecting. So it's a difficult process, but ultimately with the whole notion of prompt payment, you want those earlier finishing trades to be able to get their holdback, within 60 days or what will be 60 days from finishing their work. So there'll be changes advocating for that. You will have the ability, not that there was a restriction of the current act, but I think there's going to be an express provision that will allow you to post a letter of credit or what will be characterized as a holdback bond, and I've done this in my practice in the past, to replace holdback. So if you think that the cash flow from your holdback will be better served by you getting your 10% on each draw, you can go to the expense of having a letter of credit posted or a holdback bond posted based on their recommendations and have that as your security for the holdback, and get paid your actual cash for the holdback with each draw. The next recommendation I want to address is improved protection on leaseholds and renovations. Okay. Ultimately, again, what we have now under the current act is kind of a weird situation that if you're doing work on a tenant fit-up, you have to give notice 10 days before you start your work to the owner, and they have 10 days to respond to your written notice. Your written notice has to identify the work you're performing, who you're working for, and so on. And if the landlord does not respond, then your lien can attach to the landlord's interest in title, to what is often referred to as the fee simple interest or the root title ownership. If you don't give that notice, and most people don't because they don't know provisions in sections 18 and 19 of the current act, but if you don't give that notice, then your lien can only attach, if you're unpaid, your lien can only attach to the leasehold interest. Well, what's the value in a leasehold interest? It's a nominal value. You know, you could sell a lease or some of the assets of the lease, but it's not exactly going to give you the leverage you need. You would still have what is called a charge against the holdback. Your lien would still be a claim against, you know, if you're a subcontractor, the tenant's holdback that it would have on the payments made to the general contractor, but it's not giving you a good piece of leverage for security of payment. So the recommendations that they've included would be that a landlord that provides funds for an improvement or an improvement incentive would be automatically liable to a lien. So your lien would be able to, if I'm doing a tenant fit up, and if there's some kind of inducement by the landlord for the tenant for any of the fit up that has to be done, then your lien can attach to the fee simple interest, go right to root title, which is important. The other problem we have when I register liens against leasehold interest, and this arises often, is that when I search title, that particular tenant's lease may not be registered, and most times it's not registered on title. So how do I know if I'm on for a subcontractor, the only piece of information I might have is the general contractor's name, because we have a contract with the general, but I don't necessarily have a copy of the prime contract between the general and that tenant, and I may not know the tenant's name. And in fact, I may not know what parcel on this plot of land might be the tenancy. So information relating to all of that will be much more, I guess, easier to access if these recommendations go through. So it is a problem when you're registering against leasehold interest. Okay. The next recommendation deals with mandatory project trusts. So in some jurisdictions, for example, in Alberta, the trust only arises when you make the last payment for holdback, then those are characterized as trust funds. You have other jurisdictions like BC that have actual arrangements to set up bank accounts. So you have a joint bank account which will reflect the trust. What the recommendations come here, we're trying to emulate what goes on in New York State's Mechanics Lien Act, so that you will have, I guess, a mandatory record-keeping standard associated with trust funds. So let me back up a little bit. In the Construction Lien Act as it's currently drafted, Part 2, Sections 8 through 13, had nothing to do with registration of a claim for lien on title, had nothing to do with 45 days. They are what are called the trust provisions. And ultimately what they provide is for every dollar that comes into the hands of the owner holds that money in trust for the benefit of the general contractor. And when it's paid to the general contractor on account of work that was performed by subcontractors, the general contractor then holds that money in trust for the benefit of the subcontractors. And why is that important? Well, a trust is the highest legal obligation an individual or company can owe to any other individual or company. So it has 400 years of rules attached to it, and it's very stringent rules, very difficult. If you're an executor in an estate, for example, you are in a position of trust. You have fiduciary obligations that are associated with that trust, and therefore you must carry out the instructions of what was in the will or the codicil. You can't go and pocket the money yourself. You have a duty to account. You have a duty to follow those instructions. Well, those same types of instructions and duties flow through under what is here a statutory trust that arises and applies to every project except those involving a municipal corporation or the provincial crown. So what they're advocating is setting up something that is similar to what's in New York State as a pilot project, where you would have some record-keeping requirements, therefore making it a lot easier if you're going to make a trust claim to find out where your money was spent. And again, the province are recommending that the province work with the Surety Association to define standard bonds also, which will be referenced by regulation, which will include a payment protocol. So they also want the bonding of provincial projects to be mandatory as well. The next key reform suggestion comes from adjudication. Okay, and what is adjudication? Well, adjudication is simply, my take on it, is getting to a resolution of a dispute, and they've modeled it on something that happens largely in the United Kingdom. It's a quick, project-specific adjudication. You don't need a judge. You don't necessarily need a lawyer. Your adjudicator can be an engineer, architect, somebody who's not, affiliated with the parties or the project, but it's simply getting to a resolution quickly, and they've characterized this as adjudication. So the decisions from the adjudicator will be binding and must be implemented. They're enforceable through the courts. You will have a right to appeal. Your lien rights won't be diminished by what they're suggesting for this adjudication model. And again, as I mentioned earlier, after an adjudication order, a payer is still in default. The contractor has the right to suspend work, and I think that's important leverage that you would have if they're not following through on the adjudication decision. The model that they've set up in their recommendations is on 2 slides here. I've had to split it up on 2 slides, but you can see here when you look through the process how quick things are to happen. You have some steps there. It's 2 business days, to pick an adjudicator. The adjudicator responds within 2 days. If you don't agree on the adjudicator, then the parties will refer the dispute to an ANA, which would be simply, my take on it is that it'll be something, a body appointed by the government where they would appoint the adjudicator for you, okay? And then they appoint it, and then you'll have your adjudicator within a week, as you look there through the slides. I'll just leave this up here for another 10 seconds so you can read through the slides, but the ANA would essentially be a board of the government that you would submit your dispute to have somebody assign an adjudicator to the parties. And then the process, the next slide simply continues down what I've cut and pasted out of the Reynolds report. And you see there's 5 business days, then you get a referral notice, okay? And then 30 calendar days, you're going to have the adjudicator setting out the process, okay? And then you're going to get a written decision. And again, the decision will be binding on an interim basis subject to appeal. So the whole idea is effectively you're going to have these arbitrations, to use a different word, that are going to happen in a very short, small window to get things done. Whether, they hear evidence or not, ultimately they're trying to push that everything would be done in writing to make it that much faster. But it's all to push the problems that we're having with the current Lien Act and trials, and again, prompt payments. You're not waiting 2 and 3 years to get your trial date and having to finance all kinds of things in the interim. The whole impetus is to try to get to a quick and effective resolution of disputes relating to payment as quickly and as efficiently as possible. I'll leave that up there for another 10 seconds or so you can take in what's being suggested in terms of the processes. And that is, in 45 minutes, a summary of what I consider to be some of the more important highlights relating to the Reynolds report and changes that I suspect are going to come to the Construction Lien Act in the next year or years. And if you have any questions offline, my email address is there, or you can text me at that cell number, and I'll do my best to try to get back to you with an answer. And as I understand it now, Anthony and others may have some questions that they may want to ask. And we have about, I guess, 10, 15 minutes to go through some questions.
Yep, that's correct, Dan. Thanks again for trying to distill what's a massive document into a 45-minute presentation. And we'll just leave up that slide with your name, contact info, and everything for everyone, as we do have a few minutes for Q&A. And if time runs out, then do please contact Dan directly by one of those methods there. Now, Dan, when I was chatting with Sharon Vogel and Bruce Reynolds, they did admit that it was, Bill 69, prompt payment, that had pushed for the Construction Lien Act review. And, at the time when I was chatting with, then with ECAO's Errol Roberts, he wasn't looking too forward to the Lien Act review. He mentioned that the Lien Act deals with security payment, not speed of payment, and most contractors don't have the time or resources to employ the Lien Act. So while a review of the Act would be good, shelving Bill 69 is not. Now, based on everything that you've read at the result of this review, Errol said all this before the results of the review, do you think that Errol's concerns have been addressed?
I was equally pessimistic because I've been part of the process for Bill 69. I've been consulted on some of the wording associated with it and so on. I think what the Reynolds report has done everything that any advocate of prompt payment would want. They've gone as far as they can, and the title of the report is Balancing Interest. They've balanced the interest. The advocates of Bill 69 will admit that they didn't, and that includes myself, didn't look at the residential sector as much as they should have. There were issues with P3 projects, with milestone payments and so on that weren't addressed. So it was really focused solely on prompt payment. But what we have here as an overview and a total reworking of the Construction Lien Act, I think if you're an advocate of prompt payment, you would have no complaint with what's being put in the Reynolds report. Because it not only deals with prompt payment, it deals with adjudication, the whole overall system, the mandatory release of holdback. Those are all items that would assist with cash flow and getting a contractor as cash neutral as possible.
Agreed. Now, if you had to just look at it from a personal level and also as a professional level, because you deal exclusively in construction law, representing a whole number of different parties, what are your favorite bits in this report, and what problem areas do you see?
I have trouble. My favorite, I like the prompt payment, and I like the mandatory release of holdback. I just think, when you think of holdback, that is 10% of work that I've already performed. So why is there an issue with getting it released? It's on work I've already done. So why can't I get my payment quicker? I like the idea of an express provision that allows you to do a letter of credit or a holdback bond if you can afford the bond and realize that the cash flow is more important to you for that 10%. The adjudication, I like the idea. We've had in the CCDC2 since 1994 the whole notion of appointing a project mediator, and I've only been on a handful of projects in the last 25 years or so where that's been done and done effectively. That was trying to promote getting disputes resolved quickly on the job site. The adjudication model suggested here is great, and we really have to follow, and there would have to be an absolute buy-in by the industry to follow it and not resort back to simply, going to the courts, having your lien registered and so on. So I think it's going to require, I'm not being overly pessimistic on the adjudication, I just think that is a large change in mindset that, okay, we've got a dispute, let's deal with it quickly. That just doesn't happen by today's standards, and that's going to require a monumental buy-in by the industry as a whole.
Mm-hmm. One question that came in, and this was near the start of your presentation when you're talking about how did we get here to the lateness of payments. And then one of the things you mentioned, Dan, is that judges in the judicial system, they're busy with family law, criminal law, all these other things, and not a lot of judges or perhaps other players in there are that familiar with the construction industry and its concerns. Now, this might be outside of the scope of this presentation and the review, but is there any discussion in terms of perhaps bringing the judiciary more up to speed with things that go on in the construction sector? Is that too big of a question, Dan?
No. I'd love to, and to some extent we have. I can speak to in Toronto and in Ottawa. We do have masters, which are pseudo judges. They can do absolutely everything that's involved in a construction lien matter. In Ottawa and Toronto, we have masters and judges who do have the ability to speak to construction lien matters. So Master Albert in Toronto, she deals with most of the construction lien matters. Master Weeb and Master Short practiced construction law. I had files with them and so on. So they're very knowledgeable about construction and construction lien matters. Master McLeod in Ottawa, who's now a judge, very knowledgeable in construction law as well. So we do have some, but that's, as a total, if you took the whole province as to who's knowledgeable, you might have 10 judges and masters in the whole province who have an understanding of what's going on, and you don't always get, well, in fact, never do you get to select your judge or your master. So bringing them up to speed in terms of construction is part of the process at the outset of the hearing, but educating them, I would never tell a judge how to do anything like that, and ultimately they don't want you in court anyways. They want you to go to arbitration. They want you out of the court system. It costs money for them, and they've got other priorities, like I said, with criminal and family law matters. So that's why this adjudication model will be quick, project-specific, mini arbitrations that will happen. So yeah, I wouldn't want to be trying to explain judges or educating them or telling them why they need to be educated in terms of the construction law industry.
Fair enough, fair answer. And now, just as I wrap things up, and again, we've got Dan's contact information there. If there are some questions that you have for him that you would like to take offline, that's fine. But now, our listeners, or actually, before I get to this, so right now the report is with the Attorney General. Now, in terms of any possible legislation that's being drafted, do our listeners, or do they have any outlets if they have concerns with the report, things that they see that they would still perhaps like to see changed or like to have an impact on the legislation before it becomes legislation? Is there anything they can do, anyone they can turn to, anyone they can put pressure on to still influence that legislation before it becomes legislation?
Well, I would turn to, obviously most of them would be members of construction-specific associations, so whether it's the Mechanical Contract Association of Ontario, Electrical Contract Association of Ontario, if you're an architect, the OAA, I would contact your membership group and association, because many of them made specific submissions to the Reynolds group when they were going through drafting the report, but they may already have something on hand, maybe already have an answer, or I've already made a submission to the government relating to concerns that they have, or if they want to support certain portions of it. So I would recommend that they contact their association group with their comments and concerns, and there may be certain filtering of information that flows down to them specifically as well.
Excellent. Very good. Good advice. Well, thanks again, Dan, for your insights, and thanks to all of you out there for taking the time to attend. As always, stay tuned to Electrical Business Magazine and ebmag.com. As Construction Lien Act updates happen, we'll publish information about that. And please mark January 12, 2017 on your calendar for Andrew Houston's next Profit for Contractors webinar entitled Make 2017 Your Best Year for Profits and Freedom. Again, thanks to all of you for attending. Dan, I know you're busy. Thanks for taking the time to attend to walk us through this. All of you, please have a safe and festive holiday season, and thanks again for tuning in.